I'll call the meeting to order. It's a meeting of the Town of Norton Zoning Board of Appeals. We have a few items, several items listed on the agenda tonight. This meeting is being held under the state's emergency orders and guidelines concerning the COVID-19 pandemic. It's being held via remote means with reasonable access permitted for the public and for participants to hear what's going on, observe what's going on, and also to be heard. The agenda was posted for tonight's meeting. It has the sign-on information for this web Zoom joining the meeting this way. There are also call-in numbers listed on that meeting agenda and on the notice of meeting with a meeting ID. In addition, please feel free to email questions ahead of the meeting or during the meeting to CUNEON, that's Cunion, CUNEON, sorry, at nortonmaus.com, nortonmaus.com, if there are any questions. But we provided access by video and telephonic means otherwise. The first item on the agenda, marked for 7 o'clock, is an application for 0 Knollwood Street, property address, Philip Ibrahim and Deborah A. Ibrahim, trustee. The second item on the agenda, I'm going to also call at this point the application for 139 Newland Street, Anthony Tassolari and Jacobs, Carl E., estate of Carl E. Jacobs, I think is the applicant, the other listed party. These two agenda items, I believe we've communicated to the applicants prior to the meeting. These two agenda items are going to have to be continued because of a noticing error that was not of our making. Apparently the Sun Chronicle did not advertise post the meeting as required under Mass state law and the bylaws. And so we are unable to have a public hearing tonight. I will ask for a motion in each case from the members to continue these to the meeting of, and the next meeting is March 24, correct, Paul, at 7 p.m.?
Yeah, correct.
Again, there was a problem getting the application notice into the Sun Chronicle in time for publication as required under Mass law. So we're going to have to put these off till the next month. With our apologies to the applicants, my understanding is it was not our office's doing it all. It was some inadvertence, inattention from the Sun Chronicle. In any event, sitting as voting members tonight, myself, Tom Noel, I'm the chair of the board. Also with me is Jim Tenore and David Wren as the other two voting members. Alan Booley is here as an alternate tonight. May I have a motion to continue the 0 Knollwood Street application, the Ibrahim application, to the next scheduled meeting at March 24 at 7 p.m.
Mr. Chairman, I'll make a motion, Dave Wren, to move the 0 Knollwood application to the next scheduled meeting at March 24th at 7 p.m.
I will second. This is Tenor.
Thank you. We have to do roll call votes at these Zoom meetings. Mr. Wren, how do you vote on the motion to continue?
I vote yes.
Mr. Tenore, how do you vote?
Yes.
And Mr. Noel votes yes as well. Next, is there a motion to continue for the same purpose just announced, the public hearing for 139 Newland Street? the Tassalari application to our next meeting, which is March 24th at, let's say, 7:05 p.m.
Mr. Chairman, I will make a motion to move the public meeting for 139 Newland Street to 7:05 on March 24th.
Is there a second?
I will second.
Okay, Mr. Wren, how do you vote on the motion to continue for the record?
I vote yes to continue.
Mr. Tenore
Yes.
and Mr. Noel votes yes to continue that item as well. To the applicants, our apologies. We will resume though on March 24th to consider these applications. I will move on to the next agenda item for the record at 7:08. This is posted as a remand hearing. It's an appeal of building commissioner action. The property address is 242 Mansfield Ave. The applicant, appellant, is Stephen Bankert. And just some history recited for a moment, if I may. This stems from an action that the board took, some of the board members will remember, back in 2000, actually we took action in 2019. This was first before us in and during 2018. Jim, you were on this application at the time, and I think Lucas, who's not here tonight, was the third, another voting member on at that time. So you may remember this. This is the property location is what we fondly refer to as the old Norton mini golf location, 242 Mansfield Ave. We have an extensive record in the file. I will say that we've been advised by town council, however, that this public hearing should not occur tonight because the applicant, Mr. Bankert, has declined to pay the required fees and to submit the papers to post the notice of meeting to the Sun Chronicle. This is a similar issue, but a different reason. I am cognizant of quite a bit of communication in the file over the last several weeks between Mr. DiGiuseppe on our behalf and town council and Mr. Bankert concerning the need to properly notice the meeting and post the meeting. This is on a remand from a Superior Court judge that occurred in November of 2019, actually, just over a year ago, remanding from an appeal of our decision that Mr. Bankert made back in 2019. We found at that time the application to be moot because the special parking permit had expired months earlier, and it wasn't clear to us that we could render a decision that made any sense at the time. I will, just to describe briefly, and I'll let the record speak for itself, but an appeal was taken of that decision to Superior Court, and it resulted in the order that I referenced a moment ago, remanding the matter for further hearing before this board. And while it's the practice and policy on remand to not have the applicant reapply and pay for new application fees, the requirement still stands, according to council, under Massachusetts general law and the bylaws, to the requirement to notice and properly advertise the meeting. The applicant has declined to do so, and as of at least a few days ago, that was the position of the applicant. Mr. DiGiuseppe, has anything changed after my brief summary of just now? Has anything changed with respect to the fee issue?
No, nothing has changed. And I just want to clarify that we actually told him, as a practice, whenever we get a remanded application, we do not we do not charge the filing fee. We were only asking for the fee for the Sun Chronicle, and then the abutters, they have to pay for an abutters list, and then the notice to the abutters.
Correct.
That was declined.
Correct.
The applicant
It's the
declined.
noticing fees that were declined.
Yeah.
If we, the town has a practice of waiving the application fee for a remand. In other words, the court sent it back to us, but we still have to notice the meeting. Town council has advised us that we should not open a public hearing and take any evidence on this or consider the substance without that. Having said that, and there's much more detail in the record, and if I got any particular detail wrong, I think I got the gist of it, the ebb and flow of the case right. Having said that, is Mr. Bankert present at the meeting at this particular time? I don't see the name Stephen Bankert listed. I see one phone, last four digits, 9843. Is that Mr. Bankert? Or is that perhaps our own staff? No one is responding. Paul, are you aware of Mr. Bankert's attendance?
As far as the email provided, he adamantly disagreed with this even going to here to the ZBA. So
I'm not aware of Mr. Bankert's presence at the meeting.
no, I don't see him. And I'd want to point out to the other board members that I provided him with the direct link for all the ways that he could have participated in the meeting tonight.
And it's also on the notice of media and the agenda that was posted, of course.
Yes.
And having reviewed the extensive communications, I can certainly second that. And I think Paul and town council went out of their way to explain the differentiation in the application fees and the notice and posting requirements. Notice and posting is required by state law. We have to give notice to abutters, neighbors, and to the world as the law as it's described, that this application is on. And the applicant has declined to fund that. For the record, I was going to ask Mr. Bankert at this meeting whether he was willing to reconsider that posting requirement and providing the funds so that the meeting could be properly noticed and butters notified, and offer to, if he agreed to do that, I was going to offer to continue this as well to the next meeting, the March 24th meeting. But again, for the record, it does not appear that Mr. Bankert is here, and nobody has spoken up as a representative of Stephen Bankert. Is that correct? There is nobody in attendance to represent Mr. Bankert? For the record, seeing and hearing none, I will suggest to the board then that council has advised that we deny the application, which is an appeal of the building commissioner's original action, because the appellant, though this board was ordered to resume a hearing, to hold a hearing, the applicant has declined to follow the procedural rules to provide funds to the town to properly notice the meeting. Just for brief further history, this was concerning operating a commercial parking lot during the Xfinity concerts, which the appellant had done for a time, including the 2018 season. There were issues and complaints from various town officials, including the police department and fire department, concerning activity that was going on in and around the lot, concerning the number of cars parked there, concerning the spacing of cars. and specifically illegal activity that was alleged to have been going on there. When we held these hearings in 2000, when we started this original hearing in 2018, the applicant declined to answer questions because at that point he had been arrested by the town of Norton, and he and his counsel appeared to say that he would not answer any questions concerning the allegations of what activity did or did not take place at the permitted facility, asserting his Fifth Amendment rights against self-incrimination. We consulted counsel at that time, and after several meetings, insisted that Mr. Banker's counsel give us some kind of deadline as to when the criminal allegations were to be disposed of. He had asked for a 6-month extension. That was at, I believe, the February 2019 meeting. And counsel at that meeting advised that the matter was moot because the permit had expired in September of 18. I think it was September. Again, the fine details, I may be off by a week or two, but I believe it was the end of September of 18. So we declared the application moot at that time. Mr. Bankert appealed that. The judge eventually heard that, and for whatever reason that's not apparent to me in the record, there's a simple one paragraph order saying that the hearing would be remanded to the board. That's what brings us to would be remanded, and that the applicant was to notify us when the criminal matter was disposed of, which he did earlier in 2020. That brings us to tonight and the present issue that I've just described. So without a public hearing and now without the applicant taking part, I'm going to suggest to the board that we discuss, it's not a public hearing, we're not hearing from anybody else, but I will discuss with the board what to do to dispose of this matter. Jim, you, I think, will remember some of this from 2.5 years ago, 2 years ago. It was 2 years ago this month that we made the decision that the application was moot because the commercial parking permit had expired, would have expired anyway in September. Do you have anything to add, Jim, by way of discussion on this matter? You have to unmute, Jim.
Sorry, I had to switch from my computer to my phone. Something's going on with my Surface Pro, but no, I think you described it basically to the T. I remember the details. I'm a little surprised at the judge not telling us why he kicked it back, and why we need to reconsider and move forward, because that's typically what they do in their rendering.
Well, I agree. For the record, what we have is, I'll just note it. I can find it. When I find it, I mean. Because that's what I do. I shuffle papers all day for a living. I'll always find it, but it's always a shuffle. This is the order dated November 6, 2019. Plaintiff's claims are not moot. Matter remanded to the Zoning Board of Appeals to conduct a further hearing and make a decision on the merits. Hearing, I'm just summarizing, to be scheduled after the resolution of the criminal matter pending against the applicant, the plaintiff. Plaintiff is to notify town council within 30 days of the resolution of the pending criminal matter. That's the only thing that the order said. We weren't present for the argument, but the order is what we were operating off of. So the town is attempting to supply that remand hearing. The rest of the communications are part of the record for anyone to inspect. I'm not going to go through and read all of them. I think I've summarized accurately that the applicant declined to fill out a form by which to provide notice and advertising.
And just so I'm clear, if he wasn't to fill out the form or pay the advertising, do we know if he would have been here today? I mean, I guess we can only assume, right?
Yeah, I can't answer that because,
Right.
I mean, we said we're going to schedule this tonight. There was specific communication saying from Paul and council, town council, saying the zoning board is putting it on its agenda for February 17th, but we need to provide notice to abutters and publish, as we always have to do. But the message was clear that this was going on the agenda for tonight. And there were final communications from Paul just, I think, a week ago saying exactly that.
I mean, I think
Providing.
I would feel the refusal to fill out the correct forms is justification enough for us to
Well,
do
it's
what.
not, yeah, and it's not, we're not doing anything to penalize the applicant. We're simply saying that there can't, the council has advised that there can't be a public hearing from the applicant, even if it's not properly noticed.
Right.
So we have this opportunity. We're trying to give the applicant the opportunity. He's declined to participate, at which time he could have stated his case. We could have made a decision, or perhaps continued it again to hear from the town officials that were cited. If the applicant was to say none of that happened, back in 2018, perhaps we would then want to hear from some of the officers involved. Though the criminal matter was disposed of, I don't even know how it was disposed. I just don't know how that ended up. We're simply acting pursuant to the order of the judge. With that, I would suggest a motion to deny the application for an appeal of the building commissioner's revocation of the 2018 permit due to the fact that the applicant appellant has refused to provide funds for abutter notification and publication pursuant to Mass General Law 40A, Section 11, and the Norton bylaws. Is there such a motion?
I will make that motion.
Mr. Corey?
I will second.
Okay, is there any further discussion on this? I can say also from the record and the communications, which are of record and on file, and anyone can look at them at any time, the applicant has also alleged that there was constructive approval from the town back in October, and has said again there was constructive approval this time because we didn't hear him soon enough. There are steps that he can take to try to justify that constructive approval if he wishes to do so. But at this point, I think that our options are somewhat limited, again, per the advice of counsel. I'll ask for unless there's further question or discussion from the board, Mr. Tenori. Mr. Tenori, how do you vote on the motion to deny the application to overturn the revocation?
Yes.
Mr. Wren, how do you vote?
I vote yes also.
And Mr. Noel votes yes as well. We will draw up a decision and have it entered and posted within the required 14 days on this matter, and provide notice as we're required to do under the statute. Okay, moving on to our next item on our busy and somewhat confusing agenda. This is the public hearing for the property address of 253 Mansfield Ave. This is not the comprehensive permit. This is an application for a variance to construct a sign. File number 21-08, property address 253 Mansfield Avenue. Stand by. The applicant is, the owner is listed as the Ruscido Brothers LLC. That is also the name of the applicant. Here representing the applicant, I believe I see Attorney Valenzola.
Yes, good evening, Mr. Chairman, members of the board, Edward Valenzola for the applicant.
Thank you. Are
LLC.
you speaking for the applicant tonight on this issue?
Yes, I am, sir.
Okay, just to summarize quickly, this is a building that's also, well, the location is before us for the next item on the agenda, the 40B comprehensive permit application. But this is a separate issue. Apparently somebody who was impatient and not observing the driving laws of the Commonwealth took out the sign that was in front of the building back a few months ago. And the applicant is asking for permission to, well, for a variance to reconstruct the sign that had been out in front of the building for years, of course, but I'll let Mr. Valenzola simply summarize, if you can, briefly, why is a variance necessary for this sign?
Yes, thank you, Mr. Chairman, members of the board, Edward Valenzola with Valenzola Law Group in Mansfield. So the section of the bylaw that applies here is 175-8.5 regarding non-conforming signs. This sign was built back in 1983. And it had the protection of being a legal non-conforming sign at the time of the incident back in September. The driver on September 12, 2020 was operating under the influence, was cited, was also, there was a second citation in the operator's report. It's not clear what it's for. They oftentimes redact the exact reason. You have attached to the application several photographs, which I understand may or may not be uploaded, but one of them shows clearly it's a complete demolition. The sign is wiped out, and it's thrown across the parking area. So what we're trying to do here, and this has nothing to do with your next hearing on the 40B. I mean, we're just trying to put back in place what existed before September 2020, which was a sign that's approximately 81.25 square feet. And the sign, you have a rendering of the two signs, the sign that was demolished and the new sign. And I think the language, the way it's written in the sign photograph is proposed 74.75. I think what they're saying in this photograph is that if they had to comply with zoning bylaw, the new sign would be 74.75. And you can see what it looks like. It's black, it's more modernized, updated. The existing sign, which says 81.25, that shows the sign that was demolished, and that's the size we want. We want what was there before. We're not asking for any more or any less, but it will look like the new sign that is to the right.
I have to question you on that, and I'm sorry to interrupt.
Go ahead.
The page that I'm looking at that shows the two signs side by side, and I don't find a good legend for the they all have the Pro Sign Graphics LLC.
Right.
It says proposed sign on the right, so I think, isn't that what the application is seeking here?
Well, I think what they're, and I saw this when I was reviewing it this afternoon. I think what they're saying is that that's what the sign will look like, and if they have to comply with the bylaw, it'll be 74.75 square feet. They want it to look like that, and we may have to give you a new plan. But on the left, they want it to be what was existing before, 81.25 square feet.
That's not, okay, that's not stated in the application though, I don't think. The application asked to rebuild sign that was knocked down by driver cited for OUI. See Exhibit A incorporated herein. So the problem, I mean, the question I had is, what is the variance for? Because the sign, I think it's for an oversized sign. Either one of these would be an oversized sign. And so I understood the application as far as that was concerned. But I'm confused now as to why we would be shown different dimensions for what's labeled as existing and what's labeled as proposed.
I think what ProSign was trying to do was show that this is, if we have to comply with the zoning bylaw, you're going to get we're going to have a 74.75 square foot sign that's going to be black, as you can see there. But on the left,
That doesn't comply though. That doesn't comply, does it? It's not stated, but the sign bylaw, I think I printed it out. Yeah, here it is. It's 175-8.4B. This is commercial zoning district, correct?
right? Yes.
One freestanding sign per street frontage not to exceed 12 feet in height, 48 square feet in sign area is allowed per 120 feet of street frontage. So the old sign was oversized and what's labeled as proposed sign is oversized. So I think we have to.
Yeah, I think I'm sorry. I think I misspoke. I'm not being clear. So the old sign was 81.25 square feet. The proposed sign doesn't comply, the 74.75 square feet, but it's actually smaller than what was destroyed.
Correct.
So, and we have tenants that have, as you can see, there's different tenant names on the signs, and in the leases, we have requirements where tenants have the right to be on the pylon as it existed at the time, the leases were entered into. So we want to be careful about reducing it too much, but it has been reduced some from what existed before. So we're hoping, this just puts back in place. And if the 40B goes forward, obviously this is something that's not going to be needed down the road, but we don't know. I've permitted a lot of properties in my 40 years, and sometimes you get the permits, but it doesn't move forward as far as the construction. So we just want to try to put back in place what existed back in September.
Fair enough, that's fine. But so that my interpretation, I just want to make clear, is for proposed replacement sign being the proposed sign of overall 74.75 square feet.
Right, the one on the right, the black one.
Correct. Okay, I just wanted to make sure for the record, if a variance is granted, it will be to that specific dimension. So we want to get right which one we're talking about. And that is, for the record, a reduction. The old one was 81.25 square feet. This is 74.75 square feet in area of the panel, according to this plan. It's 8 feet off the ground, just like the old one was, 5 feet wide. And the photos show the old sign, I think, is Exhibit B, and Exhibit A is the demolished sign. Are there questions from the members of the board?
I don't have any.
So the variance is requested because it's an oversized sign proposed. There was an oversized sign there before, but the bylaw says what it says for commercial zones. It limits the size. So the applicant's asking to replace the sign with a slightly smaller version in the same location, 10 feet off the frontage, the front setback.
I guess one of the questions I have is, did they have a variance for the sign that they had before?
Back in 1983, when it was built, no, I don't believe there was a variance. I believe it's, the so-called grandfathering. It complied at the time, so it enjoyed the grandfathering status, which is the Section A of 175-8.5. And if I may, if you look at 175-8.5, the second two sections, B and C, I mean, they say the legal non-conforming status basically is lost if you're relocating the sign, you're replacing it. If you're altering it, you're maintaining it or repairing it. Deterioration, this is none of those things. This is a damage due to a casualty. If there was a fire there, and in this case, there's a vehicle that knocked it down because the person was operating under the influence. So this isn't just natural deterioration, or we want to make alterations, which I think 175 would apply. This is a case of casualty, which I would respectfully submit is not really addressed in that bylaw, and will give you, a peg to hang your hat on as far as, granting the variance here.
Yeah, I don't disagree. I'm not sure. We usually see non-conforming pre-existing uses that are residential zones, and we make a finding for those. But I think this is just a variance. That's what's been applied for. I note that zoning actually was instituted in Norton in the 70s, so I'm not sure if it was a pre-existing non-conforming use or not, but it was there. And now a variance, whatever was there, now a variance is being sought for this construction. And that's what's, I think that's the extent of what's before us. One thing I'd note, the application does say that the individual leases with the businesses provide that the landlord is going to provide some sign space. So, it's a requirement for the landlord to fulfill under those leases for the merchants that are there, the businesses that are there. I would take that as a hardship under the variance statute, that they have to comply. Are the businesses still located in that building, council?
Yes, they are.
Obviously, if the 40B progresses, then that will change eventually, but for now, they're still there.
That's correct, Mr. Chairman.
Okay. Are there other questions from the board?
Mr. Chairman, I guess I was just wondering if Mr. Iafredi had any concerns about the size of the sign, or?
Good evening.
Hi.
David, I don't. I think, because they're proposing a smaller sign. Me personally, I don't have any obligation to it. If they were going larger, I would look at it a little bit differently, but because they're shrinking the size a little bit, and it was there due to the accident because it came down, I don't have any objections to it.
Okay, thank you.
Thank you, Building Commissioner. It also looks to be about the same structure. In other words, 8 feet off the ground, and the panel is in the same spot, so it's not going to be much of a change from what was there. So if there are no other questions from the board, I'll ask if there's anybody else in attendance to speak in favor of the application as filed concerning this sign. For the record, is there anybody in attendance to speak in opposition to the application for variance for the sign? For the record, I don't hear or see any. I will attach to any decision at least a couple pages of what was submitted of the sign plans showing the relationship to 140, showing the placement of the old sign. It looks like this is going to be in the same spot essentially, and referring to the proposed sign with the dimensions so that there's no question as to what's being sought for variance. I would suggest that well, first, is there a motion to close the public hearing on the matter?
I'll make a motion to close the public meeting on the matter.
I'll second that. Sorry, my son's in the room. I apologize.
It's all right. He comes first.
Yeah.
It's your turn to have audio issues there, Jim.
Dude, I get every issue. My phone died. My Surface Pro died. I'm in my computer in my room. This is a terrible night.
You look like you're in Texas without power, actually. It was all dark.
Because you guys don't want to see my unmade bed, and my wife will kill me.
Don't want to see that, no. All right, there's a motion to close the public hearing portion. Mr. Wren, how do you vote on that?
I vote yes.
Mr. Tenori?
Yes.
Mr. Noel votes yes as well. So now for discussion, I think a motion to grant a variance is in order. A variance from the size requirements of 175-8.4, which says the sign in a commercial zoning district not to exceed 12 feet in height and 48 square feet in sign area. as per the proposed sign as shown on the plans. We can discuss that. I don't know that there's any negative to this at all. I'd entertain that motion if someone wants to make it, or we can discuss things further.
Yeah, I think it looks nice personally. The sign looks better than what was there, I think, and looks a little more modern. So I have no issues.
Yeah.
Same, Jim?
Yes, same.
I also note, the tenants who are there deserve to have their businesses advertised to the extent that's advertising, on the sign. So I think it's good all around. I don't see any negatives at all. Is there a motion to grant a variance for the size, meaning square footage and height restrictions of the zoning bylaw as shown on the plan?
Mr. Chairman, I'll make a motion to grant a variance under section 175-8.4 regarding size and height of the proposed sign at 253 Mansfield Ave.
Is there a second?
I will second.
Okay. There was one other element I was going to state, and I'm forgetting what it is again. Well, I can't remember what else I was going to comment on. All right, Mr. Wren, how do you vote on the, I was going to mention the hardship being that the applicant is required by their leases to have some signage for its tenants, and the fact that this was mowed down by a allegedly drunk driver. The applicant's not in this position through any fault of its own. Mr. Wren, how do you vote on the motion for the
I
variance?
vote yes.
And Jim?
Yes.
And Mr. Noel votes yes as well. Okay, thank you, council, for presenting that. We'll have a decision within the 14 days, and we'll attach some of those signed plans to make it clear what was the variance was granted for. Okay?
Thank you, Mr. Chairman, members of the board. Good night.
Thank you. Good night. Now, there's another application for 253 Mansfield Ave. Next on our agenda, the continued public hearing for a 40B, Chapter 40B comprehensive permit for 253 Mansfield Ave. The applicant owner is 253 Reservoir LLC. The applicant is seeking to construct a 60-unit residential rental apartment building, 4 stories in height, with the first story to be parking, I believe, parking exclusively, I believe. I'm shuffling papers again, but I'll get it. Who is presenting for the applicant? Who's present?
Hi, I'm Lynn Sweet from LDS Consulting Group.
Great.
And
Before us this past summer, and just for the record, we opened this, I think, back in July, late July. Had one meeting, maybe a second meeting in August, I don't remember. But the applicant then, for a few consecutive months, asked us to continue it because there were possibly other plans for the locus for the building. But the applicant recently notified us in the last few weeks, several weeks anyway, that they were going to proceed with the 40B application as submitted, although there have been some changes. Ms. Sweet, do you want to just walk us through where we are, where the applicant believes we are, and maybe what those recent changes over what we saw 6 months ago?
sure, thank you, Mr. Chairman. I also just wanted to let you know that I am joined tonight by our attorney, Paul Haverty, our traffic engineer, Jeffrey Dirk, and our civil engineer, Jim Burke. So you are correct that the last time that we met on this was when we did our overview back in July, July 29th. And we thank the board for its patience. The town was in the process of rezoning the area, and we thought it was better to take a timeout and not use the board's time. So since that time, we have made some additional submissions to the board, including our landscape plan, our lighting plan, and Jim also responded to the town's engineering peer reviewer, and the response included some updated site plans addressing some of the concerns. We've also recently, as of this afternoon, I believe, received comments from the Conservation Commission as well. They have their own peer reviewer. So we're doing a little bit of a balancing act, trying to balance your peer review concerns and their peer review concerns. And I'm sure everything will come together. So for tonight, I'm going to ask Jeff to speak a little bit on traffic and then turn it over to Jim to address the peer review matters.
Well, before we get started, thank you for bringing us up to date. Before we get started, I'd like to ask the members if they have any questions about where we are or what, how to go forward. And then I'll note a few things that I'm aware of in the record that we should attend to before we proceed further. Jim or Dave or Alan?
So I did have one question, and Paul, I voiced this last month. I said, with the other 40B project going through, we were advised that we now meet our quota. And I'd like to know, I think I asked town council if, because they put this on pause voluntarily and we move forward with the other one, does that change our status with the 40B in town?
Well, if I can answer that, to my understanding, we're talking about 195 Mansfield Ave. We did vote to approve that in January 27th, but until the decision is actually signed and entered, my understanding is that's the point at which those get tallied in the number. So the question's a good one, but I don't think we're there yet anyway. Paul, is that what you understood as well?
Well, in addition, and I haven't heard back from council, but I've had conversations with her and with Judy Barrett, who's running late. She's actually on 2 other meetings.
Good.
What the key point is when the application comes in. So even if we had gone over 10% the next day, they're still in under the 10%.
Because this applicant applied the date that they did back in,
right,
it was last year. Okay.
And what matters is what situation we were in when they applied.
Jim, does that satisfy your question?
Yeah, yes. I'd like to hear from town council, but I mean, that would, I totally understand that. I just wanted to make sure that we were, I just wanted to see if it changed anything.
Yeah, I know that it doesn't, because I asked town council a slightly different version of what you're asking, or what Paul just referred to. I asked about the decision itself, and she did tell me that it's when the decision gets signed and stamped that is considered part of the town's tally.
Okay.
And just for the record, the 10% is only a marker by which, if we were over it, we would be able to exert a little more control over what's proposed and what's granted. So it wouldn't mean the end of the application. It might mean that we go back and forth a little more. That's my understanding.
Sure.
We can clarify with town council when we get her next, Jim.
Okay.
Give us that primer.
And just that actually the units count as soon as we send the clerk's stamped decision to the state, to the Department of Housing and Community Development. But what Judy has told me is she's given me the contact person, but once they acknowledge it, then they will count that toward our 10%.
And just so the board knows, Paul and I and Judy worked after the January 27th decision to approve. we worked on the decision fairly extensively. We didn't change anything substantive, obviously, but we caught some errors, some repeated sections or paragraphs that were in different sections, switched some things around. Remember the waiver list wasn't in shape. We couldn't read it in the form that it came to us at the end because the lines got scrunched together through the miracle of computer technology. So Paul put those all on a table and we edited those. Council's looking at all of that right now. So we were eager and said, gee, we'll get this done right away. Well, right away has, it's been 2 weeks already, or maybe 3 at this point, but we're working toward it and should be at the state to have that finalized, hopefully in the next several days or a handful of days anyway. That's just the status of where we are in the other one. But that answers your question for now, Jim?
Yep.
Okay. Any other questions from the board? David, no? Okay, I'll note of interest to me, we have traffic engineering study from Gillen Associates. Sorry, is that person with us, Lynn?
Your traffic peer reviewer, that is the ZBA's traffic peer reviewer. And essentially their report said that they agreed with the findings of our traffic peer reviewer, Jeffrey Dirk from Vanessa.
Sorry, this is Gillen is ours, yes.
Yes,
Correct.
I am here.
Sorry, who is speaking?
John Gillen is here.
There you are. Okay, yeah, thank you. Hollywood Squares again. I'm sorry, didn't recognize you.
I'm gonna put myself back off again.
You don't have to do that. Thank you for explaining, Ms. Sweet. And you're a traffic engineer. If I could I take it in this order? Is that okay, Lynn?
Sure.
Okay, your traffic engineer is, identify yourself.
Hi, Mr. Chairman. For the record, my name is Jeffrey Dirk, managing partner with Vanessa Associates.
Okay, I assume you've reviewed the Gillen Associates review.
I have, and I appreciate receiving that a couple weeks before the meeting, which was very helpful.
So can you report to us, when was your report generated, for example, completed? And we have that. Did we have that from from this summer, past summer, or is that new? It was from the
yes.
summer?
Yes, Mr. Chairman. It was, the date of the report was June 17th of 2020. So you're exactly right. It was during the summertime. We made the presentation at the last public hearing. And since that time, we've had the benefit of the peer review, which again is very helpful, I think, both to us as well as to the board.
Oh, got it. Thank you for resetting my mind with where we are on this. And so the Gillen report dated January 25, in summary, looked at the Mansfield Ave at the site driveway access. And my initial question was, is that enough of a look? But the report goes on to answer it affirmatively. I did not believe that expanding the study area would serve any useful purpose. And I believe that's because of the number of daily trips that both Mr. Dirk and Mr. Gillen confirmed. Still, the board, if you want to ask a question about any of this, I'm just sort of putting it out there. That was one thing. The site area studied was just the entrance at the building itself. The study area more than adequate to assess the traffic impact of the project. That's from our peer review engineer, Mr. Gillen. The traffic volume data conclusion compared the proponent's peak hour counts with those of MassDOT historical counts, as well as another standard, and find the proponent's peak hour traffic volumes slightly higher and are therefore acceptable. Mr. Gillen?
Yes, I'm here.
I didn't.
Can I explain that?
I just wanted to question that conclusion or that statement. Are you saying that your findings are only slightly higher than the proponents?
No, what I'm saying is when the proponent did his baseline condition, looking at the existing traffic volumes on Route 140, the volumes that he had used were slightly higher than the mascot. And when he did his analysis, it was a conservative analysis based on what he found was going out there versus mascot's earlier version.
So he was using a harder or higher comparative number, you're saying?
That's right. What I was looking at was the left turns into the site and the opposing vehicles coming the other way. And since his assumption was higher, that was a better analysis.
Got it. Thank you for explaining. I just didn't read the sentence accurately. Parking considerations, if I can ask a question there, and again, to the board and to participants, I'm looking at the Gillen Associates January 25, 6-page, 5-page letter. Parking considerations, it looks like there's more than enough parking proposed. Mr. Gillen, is it too much parking proposed? In other words, there are different theories on this because we encountered it at 195 Mansfield, but if there's an excess in spaces, should we ask that some be reduced and made green space or something like that? What's your assessment of that?
From what I can see, most of the parking, most of the parking is out of, the outside. It's in the, like you said, the first floor, the first story of the building. So it's all confined. If it were outside, then we may say, I don't know, maybe part of it is, I can't remember exactly. If some of those spaces were outside, it would be possible to identify them on the plan, but not build them. But I recall most of those spaces were inside. And for that reason, I leave them as parking if they are inside.
I see. Can we ask the applicant, what is the status? Are these 107 spaces provided? Are those mostly under the first floor? I guess is that correct?
Hang on one second. I'll get that answer for you. I think we had that in our initial.
Yeah, I'm looking for a specific plan sheet. If Mr. Dirk can point us to that.
So we had
Posted even.
It's 66 interior and 43 exterior in our initial submission at 1.8 per unit, and then 5 handicap, 2 indoor and 3 outdoor.
Okay, does anybody think that's too many? I mean, I went into the process, 6 months ago thinking, well, we better have enough parking for everybody. But since then I've heard theories that, well, the concept now is to, put only the number you need there and expand if you have to. Anybody have any comment on that, either from the board or the applicant?
I just pulled up one of the old, and again, this is a floor plan that was in our Dropbox dated 6/8/20, and it says 50 standard 8x6x19 spaces internal, 12 tandem spaces internal, and 2 handicap, I think that's handicap parking spaces internal, and then 43 standard external with 3 handicap parking spaces with a total of 110. So I don't know what number's right.
That may be an older one.
It might be. I'm trying to go through.
That's the architectural drawing.
Right.
Some of the exterior spaces on the site plan have been eliminated either because of trying handicapped accessibility or fire lanes.
Okay, maybe can we, we can mark it down for the next meeting. Next time, we're talking about this. Can we isolate the parking plan and talk about that? Show us the specific plan sheet and discuss it. I'm just putting it out there for discussion. Mr. Gillen, are you raising your hand?
I do have a question. I mean, if you're going to, I'm not really familiar with Xfinity. I know where it is. I know it generates traffic. I know it generates parking. I don't know about the other apartments in that area. Do they have people that that visit them and park in their area and walk over. What I'm getting at is I know the board wants to make sure that none of those spaces are leased out during the events. And maybe you want to have a little bit of a cushion in case the people that live there do have guests over, so that there isn't parking off-site that should have been on-site. So it's almost like, instead of getting the exact number of the ITE or the land, urban code, rather than having that exact number, you might want a little bit of fluff in there, but I'd also put a condition in that those spaces are reserved for tenants and their visitors only.
Yeah, that was a question I had also, whether there's any provision for restricting Xfinity Center or whatever it's called now. Is it Tweeter? Is it Xfinity? I don't know.
I have no clue.
It's been about five different things since I've been around, but
Yeah.
is there any provision for keeping, not having commercial parking in your lot?
If I may, I will say that there is, I believe, a parking plan, and Jim may be able to speak to this a little bit more, but it is in the new site plan, page 4, shows both the building and indoor and outdoor parking. And I believe we spoke about this back in July, that the property is going to be professionally managed, that all of the parking spaces will be assigned to residents, that on concert days, much like other people living in the area, our residents will be made aware of those concerts and hopefully be able to change their traffic patterns. But there is absolutely no intention for anyone to park in the parking spaces other than our residential tenants and their guests. And
Yeah, I think I would suggest a condition that no commercial use be made of the parking spaces, for concert goers, or however we want to word that. That's acceptable, I assume.
I don't see that being a problem.
I mean, somebody has a guest going to a concert, obviously that's different, but no, we don't want it being rented out, the extra spaces being rented out. Okay.
Chair, can I weigh in just a little bit?
Sure.
Just looking at, again, Lynn's correct. I mean, it's 107 spaces overall. Majority of it's going under the, on the first level.
I see that page, thank you, yeah.
Yeah, that's about it comes out to about 1.78 spaces per unit, roughly rounding up to about 1.8, which is a little on the high side. I mean, typically you want, roughly about 1.5 spaces per unit. I mean, this is not, like with 195, we were quite a bit higher than that number.
I see.
And there were a lot more external spaces there. And, we had concerns over impervious cover and all of that. This is a much more constrained site.
Okay.
I don't know that, this doesn't seem to be really out of the ordinary. I mean, if there's a way of reducing some spaces, on the exterior.
I'm just throwing it out there for discussion because it came up in the last one, that's all. So if there's no other plan, that's fine, we can move on. Members feel free to chime in anytime.
Mr. Chairman,
Yeah,
real quick, the binder that we were provided last year, are there substantial changes to what's being proposed now? Should we disregard plans in there completely, or can we go by those? I haven't gone and compared back and forth.
well, we have an electronic version of some revised plans tonight in the Dropbox.
Correct, so there's substantial changes. I haven't gone, matched them. It's easier for me to look, sometimes it's easier for the.
Ms. Sweet?
Well, we would very much, once we're done discussing traffic, Jim Burke will talk about the changes that he's made to the site plans. Those changes are in response to the peer reviewers. I wouldn't call them substantial. I think that they're more explanatory changes, clarifying items that were requested. We have submitted 2 new plans. One is a lighting plan and one is a landscape plan. So those are in addition to the site plan set that you already received.
Okay, so we'll go through those. That's good to have Mr. Burke comment on the specific changes. That's helpful. Just a little more on this. Our peer review did a capacity calculation, and I'll note for the record there, because it may come up in another context, there were concerns that there was only one entrance and exit to this. The traffic peer review actually says the single driveway would be safer because only one place for people to be turning in and out of when there's traffic there. Our traffic reviewer says would actually be safer than two for traffic concerns. I think the fire department had some other concerns. We'll get to that a bit later. Site distance is also reviewed. There's a note here, the last line in section 6, Mr. Gillen says MassDOT will also review. Does maybe I should know this from the other project, does MassDOT automatically review because it's a state road? Either Mr. Gillen or Lynn, you're nodding your head.
Yes, it does.
I'm going to let Jeffrey speak to that. He knows the exact process.
Go ahead, Mr. Dirk.
Thank you, Mr. Chairman. So this project will require a state highway access permit from Mass DOT, so it will automatically be reviewed by Mass DOT. Any project or any project that involves any work within the state highway layout or that has a driveway within the state highway layout requires an access permit. So once we get done with the local approval process, we will be filing with Mass DOT for an access permit, and they will undertake the same kind of review that you're doing.
Okay. I guess we did do that for 195. We had to.
Yeah.
It just wasn't called out like this, so I didn't maybe ask that question. Okay, and the conclusion is that the number of additional trips is marginal, is minimal. And so our traffic peer review agrees with the applicant's traffic peer review that the study back from June, way back then, was done properly and reached essentially the same conclusions, that this would not significantly impact the traffic to the area. I think the board had concerns in the last application, 195, and while this might not increase volume, what does it do to traffic flow? We had asked the police department, Paul, we haven't received comments on that question, had we? I didn't see them.
You did.
I submitted comments to you. The chief did weigh in.
Do we have them in the box?
We should.
I can share my screen if you want to see it.
That would be great.
Yeah, sure, Jim.
Sorry, Chairman.
I gotta learn how to do that.
Hold on, let me see.
Except I'm afraid I'll pop up a picture like, you know, me doing that or something if I share the wrong thing.
Can you guys see it?
No,
Wait, hold
but
on.
it's, let me look in the,
No.
it's gotta be in the review section, right? Review comments,
Yeah, it's definitely in there. Hold on. It's
traffic peer review, fire department.
Where is it?
Okay, so it's not in this box.
it's in the.
It was an email.
I know. I thought I had copied it over.
It's under review comments. The last one, 7/31/20. But that was.
He has a more recent one.
There is a more recent one though.
Yeah, let me pull it up. My apologies. I thought I had put it there.
That's okay. I mean, when you get it, why don't you let us know?
If I could share my screen.
Because what I was starting to say is it may not increase volume in the area, but what does it do to the flow of the traffic? In other words, on concert nights, we've all experienced, you know, there's a steady line. Sometimes that line is stopped in that area. Sometimes it's flowing slowly. There are people walking on the poor, you know, roadside conditions that we have there. So what does it do to the flow? That was a concern I had. Mr. Gillen didn't really speak to that. I know we had raised that to the police department, and that's what I was interested in hearing about or from. Lynn, do you know the date of the email, or was that the July
I can
one?
share it, Chair. I have it.
You have it.
I can share it. And again, my apologies. I certainly meant to put it.
I thought I had seen it before too, but
I
then
forwarded it. I emailed it to you all, but I certainly meant to put it in Dropbox.
Yeah, that's where I went looking
No.
to. So.
Yeah.
Are you seeing my screen now?
Yeah.
This is I think this is mine.
Yeah, that's yours.
So this is dated, let me just read it. Oh, it's dated just 2/11/21 from Chief Brian Clark. Okay, traffic during concert events, source of community residential complaints, most event traffic seen between the hours of 3 to 8. This is a common time people would be returning or going to work. Traffic cones typically placed along the line from Xfinity Center to Cumberland Farms. Is this on that line or is this beyond that line? Sorry.
It's on that line.
This is right across from, right? Question how the town would be able to mitigate residential issues. Okay. We do, here's what I was, I think I did see this. It was just a week ago and I didn't even remember being an email. We do have additional officers assigned for concerts, though I wouldn't rule it out adding an officer to try and assist. I don't see that specifically adding an officer to the location would be of much value due to the location. The same traffic issues will be raised with limited ability of additional officer to assist. We have had other long-established commercial areas developed, which have turned to have residential surrounding it only to have complaints from the residents. Okay, so it looks like the chief is concerned about residents complaining about the traffic and the pattern being somewhat further disrupted. That's my interpretation of this. But noted for the record. And Mr. Gillen, I see your hand. Thanks, Paul.
Good to see you again. I'm sorry. But the two things that I was also concerned, as you recall, I did a little bit of review for you on the other project as well, and that's the one that I recommended just through the mirror left turn lane into the site at 195. I was a little bit concerned about making sure that the left turns into the site wouldn't back the traffic up to the Mansfield shopping center, although I don't know why I care about them. But anyways, the left turns into the site based on their projections and mine, there's only going to be 3 left turns into the site in the morning peak hour, and with Xfinity, whatever it is, they're not even operating during the morning peak hour anyway. And in the afternoon peak hour, the heavy commuter traffic is heading away from Route 495 instead of to it. And we look at the opposing traffic as well. The number of people that'll be pulling into the site is somewhere around 10. Both Jeff and I don't want to speak for him, but looking at the numbers, that's about 10, which is about 1 every 6 minutes to take a left turn into the site. And since you have traffic signals further down by the dock, a little bit beyond that, you will have artificial gaps that'll be floating, and there's only 1 every 6 minutes taking the left into the site. And I don't think that that's going to meet the warrants for there are warrants for saying that you have so many turns and so many opposing traffic, then you should consider putting a left turn lane in there. Well, we don't have a left turn lane now. There is no way to mirror one on the other side into that single family home. So what I'm saying is I'm aware of the left turns, the 3 in the morning and the 10 in the afternoon, but I don't think it would warrant it, and the state will look at that anyways. The other thing in the back of my mind was right now you have a 27,000, almost 28,000 square foot building in there that has commercial traffic, it has employees, it has truck traffic, and we're going down to about 20 to 25 and very, very low left turns into the site. You know, so I didn't think it was worth, you know, widening out 140. And sometimes when you widen out a road, you increase the speeds. So I didn't think it was warranted. Looking at the numbers, it's not warranted. So, I mean, maybe Jeff wants to speak to that a little bit himself, but.
Understood, and I didn't spot that until now. You did comment on it in your report, and I skipped right over that, though I had highlighted it. I see that does not warrant another extended left turn lane there. Got it. I see that. Thank you.
Okay, thank you.
Members, are you satisfied with that analysis, or any questions?
Nope.
It sounds like the police department is, you know, concerned, but it's marginal. The increase is going to be fairly limited and marginal. I mean, it's a tough location anyway, and there are turns there. And also, as Mr. Gillen pointed out, I think this actually is a lower volume overall per day than the commercial, which was a surprise to me. But I guess if you think about it, that makes sense. Maybe fewer coming and going. So I'm ready to move off from that issue unless members have any other questions. Okay.
Yeah, I don't have any questions.
Okay, thanks. Mr. Gillen, thank you. And Mr. Dirk, thank you very much for assisting there. Next, maybe it makes sense to go over the engineering and to have your engineer explain the new stuff or the changes. Is that suggested?
Sure. There was one matter that Jeff was going to speak to that was brought up in the engineering report about the crosswalk. And then so that way I can let him go if you don't mind.
I don't want you to let him go, but yeah, sure. Mr. Dirk?
Thank you, Mr. Chairman, and thank you. I'll just be very brief in terms of the, just one area on Mr. Brennan's report that I was asked to respond to. It was with regards to the request for a crosswalk or at the driveway to the project site. So as we talked about earlier, that Route 140 is a state highway under Mass DOT jurisdiction. The locations where the crosswalk was suggested, the sidewalk is on the opposite side of the street. So it's logical that to the extent that you desire to have a connection between the site and a crosswalk on the other side, that you propose a crosswalk. However, in this case, that it would be what's deemed a mid-block crosswalk. And a mid-block crosswalk, especially along Route 140, which is opposed to the speed limit of 45 miles an hour, would not be approved by Mass DOT, just because it's an unexpected conflict for vehicles. They don't expect pedestrians to be crossing except at intersections. So it's not something that Mass DOT would approve. We did indicate that to the extent that a crossing was to be provided at this location, again, it's our opinion Mass DOT would not approve a crosswalk. It would need to be a lighted crosswalk, meaning that it would have to have push buttons with flashing warning beacons there. And so we had estimated that to the extent that that was to happen, we had estimated a cost of about $100,000. And I really think it's a long way of responding to Mr. Brendan's comment, which was really to substantiate why the cost of a crosswalk was $100,000, because there was no backup provided for that. So logically, it's, you know, if you're going to pay two lines, that can't cost $100,000. So the question is certainly reasonable. And we just wanted to clarify that the reason for the high cost was because, again, we do not believe that a crosswalk would be permitted here. In fact, I would not recommend it, and I wouldn't design it because it's not safe. It would have to have a flashing beacon, and that's why the cost was $100,000. So I just wanted to clarify that.
I guess we have two of those in town now at the extent of 123 by Wheaton College.
Correct.
Two there, right? Two of them.
Yeah. No, I think you, at least one. I don't know.
I thought there was one down by the other parking area. Maybe that doesn't have lights on it. The one at the dip.
There are multiple. There's two or three.
There's two with beacons, and I think there's one without, if my memory serves me correctly.
Okay.
Oh, the
Yeah.
third one has a light, has the, it's a pedestrian light. It's not the
Yeah.
flasher.
Yeah,
Right.
yeah, but there are a few, Mr. Chair, you're right. There's a few on 123 by.
Okay. But that's what you're referring to, Mr. Dirk, that kind of setup.
That's correct. So again, it's a long way of just responding to Mr. Brennan's question, because again, there was no backup provided for the cost estimate we gave him. So legitimately, I would ask the same question: is how did you come up with $100,000? And that's the reason. It's because it would have to have the flashing beacon.
I have one question. Can we, and this is something I just thought of right now. And maybe this would be better suited for Chief Clark. Are there any traffic or pedestrian accidents coming from the apartments just south of Alberto's? You know those apartments along on the east side, and they're right basically across from the ice cream, New England ice cream.
Across from the ice cream and the
Has there been any
Golf.
sort of have there been any sort of pedestrian incidents involving anybody going from those apartments over to like try and get to Cumberland Farms?
So I could only, so the only locations we looked at was within 1,000 feet of the project site, and within 1,000 feet of the, I don't know if in fact that would be within 1,000 feet, but if it is, there was only 2 crashes along the roadway, and I do not believe that they involve pedestrians. But you know, the chief is obviously very much more familiar with what he's responded to in that area, so it's probably something better directed to him to answer.
you could certainly ask that, Jim, ask the chief to give us that information.
I guess my original concern was people coming across going to Cumberland Farms, and where it being obviously 140. But I guess if there is in recent history any pedestrian involvement accidents or anything like that coming south of the location, then I guess my concern would go down.
Got it. Well, let's ask the chief to chime in if he can, if he has any statistics. Well, there are statistics, so we can ask him that question in the interim.
Well, fire. I mean, or I guess that would be rescue at that point, right?
But I guess so.
I'll ask the chief.
There's one other crosswalk comes to mind across from Speedway, that goes to the complex, the elderly housing complex, and forgive me if it's not an elderly housing complex. Right across from Speedway on 123.
Right, the Norton Housing Authority.
Housing authority.
Thank you. There's a crosswalk there. I don't know if that has lights. I don't think that has lights to it, but that's a crosswalk that appears kind of out of nowhere as well. I mean, we've got to take a look at what we think is reasonable, members, and we can ask for what we think is necessary for the health and safety of the town. But so it's not closed. I don't mean to close off that that discussion at all. But let's look at it. Let's look at it closely. I'm also trying to visualize exactly what's there across 140, exactly across from the apartment building. I'm not doing that.
Residential housing. I think there's 3 or 4.
The 3 homes.
Yeah.
Right.
Okay, I thought that was further up, but I may be wrong. All right,
It goes Cumberland Farms, the
mobile home.
Mobile homes.
Park, and then either 3 or 4 homes going down the side to Xfinity.
Okay. But there is a possibility of, an increase in foot traffic there. So it's a reasonable question anyway. Let's think about that and assess it. And we're not closing off that issue anyway.
Yeah, I mean, I think in general, it's very congested type of area. And we're just going to be adding people walking across, so I think it's definitely a valid concern.
Well, we can consider it going forward. Try to find out more about what the possibilities are. There's no sidewalk on this side of the street, the development side, correct?
That's correct.
Okay. Okay, in the interim, since the last meeting, what I see pretty clearly is Amory Engineers has a report of January 21, followed by DeSalle Burke Sala, a response to that of February 8th, and then Amory Engineers responding to that by letter dated February 10. And they go back and forth a little bit on several specific issues. Can I ask Mr. Brennan? I'm looking at, I didn't review these point to point yet. I mean, obviously this was dated just a few days ago. These were dated, two of these were dated just within the last few days. But maybe if we start at the end, in other words, with your February 10 letter, can you just point out to us as our peer review, what are some of the issues that are still present that you're still looking at, still going? We can go back to the other stuff and probably, we should at some point, look at these three letters side by side. But for right now, maybe if we start at the end and you can highlight what's still out there as an issue that you, our peer review, thinks we should be asking about.
Sure. For the record, Pat Brennan with Amory Engineers. And Mr. Chairman, my February 10th letter is probably the better one to start at anyway, because the comments from my January 21st are in this letter, and then I just add in bold an update to where we're at with each of those. So the first comment, that was an informational comment. The second one had to do with the list of waivers. What I find typical with the 40Bs when they come in is they kind of ask for a blanket waiver from many of the local regulations. And, I always suggest that the board ask for what specific regulations of waivers is being asked from. That way you can actually, determine whether or not granting that waiver or what the impact of granting that waiver may or may not be. And they said that they are going to update their waiver list. They haven't done that yet. So that's.
I'll thank you for that. And I'll confirm that that's what we've always done with the other 40Bs, including the one we just decided on. The waiver list, we've asked to be very specific, give us what the requirement is. And we did it in table form. Give us, on this side of the table, what the requirement is, the number of the bylaw. On the right, what are you seeking as a waiver specifically from the requirement, so that we can note them and compare them, and that we, the standard language is that, the bylaws apply except as specifically waived in this decision. So I appreciate that. And I would second that, to the applicant to be as specific as you can with the waivers needed and requested. Go ahead, Mr. Brennan.
Thank you. So my next question was about the actual feasibility of using the existing foundation from the building to construct the 4 stories or 3 stories, whatever it is, on top of it.
Yep.
And they said that they would accept a condition requiring an analysis of the structural feasibility of retaining the existing building. I think it would be safer that they actually figure that out during the permitting process, so you know whether or not this foundation staying in place or if the whole thing needs to be reconstructed. While it would still be the same footprint, it's a substantial amount of additional construction that would be required to construct the building that they're proposing. If the foundation is not structurally adequate to support what they're proposing.
In other words, the proposal is to add 4 additional stories onto what's there, or 3 additional stories onto what's there.
I believe it's 3. I believe the existing story would be used, that would be the parking, because it's a single story, but it's higher, higher walls than you'd have for a typical residential structure, or higher ceilings.
How would a comprehensive permit work anyway if it was subject to a structural analysis? Isn't that something that we would need to determine ahead of time? Isn't that something the applicant would want to determine ahead of time?
I would think so. And, you know, that's why I suggested it.
Can we ask for comment from the applicant on that issue?
I'm gonna let Anthony respond to that.
We will have our structural engineer review the building to make sure it's structurally sound to add on to it. If it's not, then we'll recreate what's there. I mean, it's part of the construction process. I think that would fall from the building department. He would review our structural engineer's plans along with our architectural plans and decide whether or not it makes sense.
Just for the record, Anthony, your last name?
Rosito?
Thank you. Just for the record.
Thank you.
Mr. Brennan, are you suggesting an independent review?
No, I think just a review from a registered structural engineer is all that's needed. And I think, you know, the applicant having his structural engineer look at it, I think is sufficient. And you know, the building commissioner is gonna, whether he's gonna require an independent structural review, you know, he may, but you know, as part of the permitting process, or at least this process, I think at least knowing whether or not it's feasible to reuse the existing foundation, I think is a legitimate question.
You know, let me ask Mr. Iafrede, does the town have the required expertise to review structural analysis on a multi-story? I mean, there are a few multi-story buildings in town, but Nick, do you have any comment here?
Yeah, so Mr. Chair, I would recommend that they have a peer review or a structure review done on the foundation, whether it's their engineer or an outsourced engineer. I don't think as of date today I have a preference, as long as it's you know, the review is satisfactory and done. I think we can hang our hats on it one way or the other. But I do agree it should be done. In my opinion, you know, at this point or throughout this process, as opposed to, you know, after the approval is given by the board, and then God forbid something happens and things might have to change. So,
if I may comment on that as well,
Sure.
It's not so much the walls being used structure that we're trying to maintain. We could build the structure inside the walls. We could put metal posts in and create the structure on the inside while maintaining the exterior walls. So there's a million ways to do it, I guess. It's just, we're not gonna dig down far into it with all those costs at this stage. Obviously, we would have to get a structural engineer, stamped plans. It would need to be approved by the building department and all that. There's multiple ways to go about it. So even if it's not structurally sound, we can still maintain the walls and go inside and build with steel. So it's a few different ways to do it.
So you're suggesting it's not necessary to do at this stage prior to permitting?
No, because we could still keep the walls and they don't have to carry any weight. We could just keep them for appearance because they've been there for a while, and we could just build on the inside. There's a bunch of ways to do this, to accomplish this.
Wouldn't that affect your underground parking?
No. So the building's about, not to get technical, it's about 72 feet wide. That's a lot more than we need for a travel lane and 2 rows of parking. So I actually have the space to post down right in the middle and use steel inside and go on top of the steel with pedestal and just basically use that block as, you know, for appearances.
Okay.
And again, my only concern is, does the town have the ability to look at that kind of engineering analysis on its own, or is that something that should be peer reviewed? I'm just throwing the question out there.
Mr. Chairman, this is Attorney Paul Haverty from Blattman, Bobrowski and Haverty representing the applicants.
Go ahead.
First off, this is a construction level detail that is not appropriately reviewed during the process of a comprehensive permit application. The applicant is only required to provide preliminary plans to the board. It's not required to provide construction level details.
Okay.
The board certainly can impose a condition in its decision that requires the submittal of the structural engineer's review, and could even impose a condition requiring a peer review of that engineering report as part of the review of the final plans.
Okay, thank you. I appreciate the guidance there.
Sure.
But the feeling is that it doesn't have to be done at this point in time, members. Members, do you have questions on that aspect? And if not, I'd ask Mr. Brennan how he feels. I think Mr. Brennan said that's probably acceptable to have the applicant do a structural analysis subject to the town construction phase.
Correct. Yeah, as long as the board's comfortable with that, I think, conditions, just like Attorney Haverty just mentioned, the condition that they do their structural analysis, and then the board can have the structural engineer review their analysis, a peer review of that later.
But that would happen after the issuance of the comprehensive permit?
Yeah, I believe so, but and I understand the main reason for that from the applicant's side. It's the cost of doing that structural analysis at this point in time. And with the comprehensive permits, we try to get the plans as far along as we can to be, near construction documents, but they're never that far along. So there's always a final set of plans that's issued as part of the comprehensive permits. So there's always a final set that would be peer reviewed.
I think to summarize what Council Mr. Haverty was saying, I think was guiding us to say that's not properly considered at this stage. I mean, we'll look at that and ask Council about that, but that's, I believe Mr. Haverty is probably steering us in the right direction there. And that's what happened with our other 40Bs. They go to building commissioner and they have to comply with all the state codes and things of that sort. And the building commissioner, that's part of his duties, his job. So I don't think it doesn't strike me as that unusual, after hearing all this from both sides. But we're not putting it to rest yet. So are there other questions at this time, though, about that structural issue? If not, if you could continue, where'd you go? Patrick,
yeah.
Mr. Brennan.
Yeah, sure. So my next comment was about the swept path analysis for the fire department vehicle, and they did provide one, but I just would recommend if you haven't received comments from the fire department to make sure that they're okay with it, because at least along the south side of the building, well, both sides actually, the fire truck cannot go in alongside either side of those buildings and be able to turn around in there. They're gonna have to back either in or back out.
Yep.
On the south side, they'll be able to turn around in front of the building, but there's no room for that on the north side. So again, that's obviously a comment that I would defer to the fire department, make sure they're comfortable with what's provided there for access.
Okay, couple notes on that. What is a swept path analysis? Is that literally the turning radius of the largest truck?
Yes. Yeah.
Okay. We do have a comment from the fire department, Deputy Chief Jason Robbins, dated February 10. I don't know if it incorporates that. It's an email. I think that is in the box, the Dropbox file. Deputy Chief Jason Robbins, February 10. I have a couple of concerns after speaking with Benny. I think that's Mr. Keene. Fire department requested a separate entrance and exit. This doesn't seem to have been met. We will no longer have complete access to the drive around the building like we currently do. This was requested to remain available. They're proposing a Geo Grid access drive along the southern side, and I have concern with moving a truck in that area before, during, or after flow of what could be lots of water. And the design plan also limits our ability, I think that should be our ability, to access the rear half of the building with the ladder truck. Is that the swept analysis, the last point?
Well, the swept analysis just shows that the truck can turn into the site without hitting any parked cars, and then back out and turn around in front of the building. Is essentially what that swept analysis shows. But
Did you say that they did do one?
They did do one. I believe it's shown on.
Do we know, Paul, did the chief review that swept analysis?
I gave the deputy chief the entire file.
Okay.
Yeah, they did do one. So they show one with the fire truck entering and going along the south side of the building, but again, they need to back out. And then they showed one with it exiting, which would be backing out and turning around in front of the building.
Can you tell us where is that on the plan? Is that the revised plan?
It's a separate plan that was submitted. I believe it was called fire truck entering and fire truck exiting.
Well, can we have a date of the plan or some guidance to get to it? Or somebody show it?
Yeah, it was submitted with the revised site plans.
Try now. Can you see that?
Yep, that's it.
So this is the entrance, I believe.
Right.
That, Tim, is that from recent? I don't remember looking at that.
So it's under, hold on. It's in the Dropbox under application. And if
So
you
it's-
go all the way down, you'll see them in the end. You got fire truck entering, fire truck exiting. I
So,
don't know the date on them.
well, I thought it was just done. That's why I'm asking, because I was looking at for some recent posting.
Yeah, that would be the,
That was, they resubmitted that, or those came in pretty recently.
that would be-
from August.
yeah, that would be the leaving. I don't know where the date on here is.
That's the swept analysis you're referring to, Mr. Brennan?
That's correct.
Okay.
Anybody want to see the other one?
Yes, please.
Hold on. See how I can do this. I gotta move screens and.
Okay. Yep. So the other path going to the rear of the building.
I think what they're referring to is they used to be able to, I think they're able to come around here now, come this way.
Well, why does this change that? Explain.
The main change, the main reason for the change is, I believe, because there is pavement behind the building now that allows vehicular access 360 degrees around the building. Much of that, the paving out back is proposed to be removed due to conservation issues.
Is that the Geo Grid reference?
So the Geo Grid, if you look at the plan that's on the screen right now, the two red rectangles that you see all the way to the right,
Yep.
They start right after the hatching that you see on the pavement there.
Yep.
So the pavement ends right at that hatching. And then that rectangular box around those two, those are the fire trucks. Around those two red rectangles is the Geo Grid, which is it makes it so that the soil is able to support the weight of the fire truck without rutting out. So there's sunlight there, and then if you look at the top of the screen, there's a smaller rectangle, let's say a proposed 10-foot wide grass Geo Grid access drive. So there's a smaller one up there too. The thing is, it just does not extend all the way around the back of the building. The back of the building is just lawn area.
So, it's this lawn area.
Correct.
Okay, whereas now it's paved?
Paved right now, yes.
You know, if I may, we are trying to balance the requests of the Conservation Commission that they want less pavement.
Yeah.
If the numerous discussions that we've had with the fire department, and this is the result, that they can get the trucks alongside, the building, but we are preserving the back area for passive recreation.
Geo Grid is it's kind of a semi-pervious.
It's completely pervious. There's a Geo Grid, which is a two-dimensional, and it's basically a crisscross of polyethylene fibers. So it's plastic. There's also a geocellular system, which is more three-dimensional, which actually either one would do the trick. The geocell, hearing the deputy chief's concern about water washing down and potentially washing out the soil, the geocell would be a better option in this situation, because the geocell would hold the soil material in place. It's tough to explain what it looks like, but I'll provide the board with some information on what the geocells look like, so you know what I'm talking about.
I'd kind of like more information on this issue altogether. I mean, I'd kind of like to talk to the fire department, maybe ask them to come in at the next meeting to ask, you know, to what extent. I mean, I see the problem, but how big of a concern is it in their judgment? And then GeoGrid wouldn't be extended around what on the screen is the right side of the building. That's not AstroTurf. That's not what GeoGrid is.
No, GeoGrid, it's still grass on top of the GeoGrid. The GeoGrid is just a soil stabilization method. So it's still soil and it's still grass. You know, grass pave is kind of a trademark name of a similar product. You know, and like I said, the three-dimensional type product, which do the grass pave or geocell, would probably be more, be a better option in this case if the fire department was going to go along with it, just because it will hold that soil in place. It won't allow it to wash down the slope.
So what I guess I'm getting to is it possible to have the right side of the screen here, a lawn area, but able to support the fire truck, or is there some other obstacle to them getting around? And maybe that's a dumb idea because people sit on the lawn and you put picnic tables there, and I'm just asking.
It may be possible. I think I'd leave that to Mr. Burke. It's his design, because underneath that lawn area, you see those two, well, I think those are existing catch basins that are shown there, but they have a subsurface infiltration system back there for the drainage, which is the plastic chambers surrounded by stone. So they would have to design that system to support the weight of the fire trucks, which may be able to be done, but I don't know, you know, right off the top of my head, I don't know if they have sufficient cover and everything else that would be required to do that.
And that might affect conservation's comments as well. I don't know if it does or not, but
it could, yeah.
Okay, so this is an issue that I think we need some more information on, it sounds like. Members, do you agree?
I agree. I had a quick question. I think I'm reading this correctly, but so I'm looking at the first picture, and that's how the fire trucks would enter. The second picture shows
Yeah, I'll go to the second.
backing up. So if I'm understanding this correctly, the fire truck would come in, and if need be, would come all the way down to the side, to the right-hand side there where the geo area is, and then they would have to back out of that spot to get back out. Is that what it was saying?
Yeah.
Yes.
Okay. I guess I can't speak to that. But I fire trucks are big trucks. I'm kind of curious. I guess I would be curious to know what the fire department's opinion of that is.
Yeah, well, I don't disagree. I think we have to ask fire department to come to the next meeting to talk to us a little about this. Because his points are related to what we're talking about, but I'm not sure they're directly responsive. The points in the email from February 10, I mean.
Right, because I think he actually makes mention that he was under the impression he would be able to loop around the building, which obviously he cannot do right now.
And that's been, he referenced Deputy Chief Keen when he was reviewing this initially, that it's usually the goal of the fire department to have full access, as Pat mentioned. And there were discussions early on about them being able to take their truck on the north side, which is that 10-foot wide access point that's there now. There were concerns about obstructions, about them getting over there, but you know, they're typically wanting to have full access if possible. And let's not forget too, this is a 4-story building, which is on the tall end in Norton too. So, I can't speak, but I would think that access is even more critical here because of the height involved versus our typical 1 or 2 story buildings.
For a ladder truck specifically.
Right. I mean, I'll ask Deputy Chief, I'll ask Jason to attend and see if he can be at the next meeting.
Yeah, I'd like to explore. I'd like to just ask him these questions and, tell us personally, be able to answer some specific questions that come up like this. That would be helpful.
Yeah, I think that'd be great. I had a quick question. Are there windows at the back side of the building? I assume there are.
Yeah. Applicant?
In the back, they're facing the reservoir?
Yeah.
Yeah, exactly. Yeah.
Yes.
I mean, not being the architect, but I would imagine there are, yes.
Yeah, I would think so. Right.
Okay.
But you wouldn't have the ability to get a fire truck back there to put a ladder up 4 stories to pull somebody out of a window. Yeah, I can't speak to it, but I just.
If I may, we submitted a set of drawings back in June that are the original drawings that are quite different than the ones that we're looking at right now that were submitted in August. And they were generated off of a conversation with the fire department through the summer and phone calls and the like. So maybe I misinterpreted, what they were saying, but it was all about getting access to the back, not necessarily looping around with the truck. But I'll certainly touch base with the fire department and discuss access and to the back of the property. I thought we had that kind of knuckled down. But certainly keep this concern open.
Well, I appreciate that contact because I don't remember what the original plan was or how this one's different, but I'll go back and look at that too.
Is it this side right here?
I don't know what we're looking at.
I mean, I don't know.
No, that's not it.
No.
So it sounds like we need to explore this at the next meeting.
Yes, I think if you go to the one right next to it, I think that might have been it.
This one?
That one, yeah. June 29, is there a revision date? No revision date, that's the original submission.
Okay.
Keep going, existing conditions. Keep going, although you go down another set, next. Oh, there we go. So we have original. That's the original set.
Okay, how is this significantly different? I'm sorry.
It's
They wanted to have access to that as far back as the corner of the building. That's
Is it
why
this right here?
the bottom part. Nope, down the bottom.
Yeah.
That's where they wanted to get access to that point, because if I remember correctly, they were talking about they would never pull the truck behind the building during a fire. That's as far back as they would go. And I believe that's what the comments were, Jim. Is that accurate?
That's what I recall, yes.
And that's why we came up with that Geo Grid to get them as far back to each corner.
Okay.
Right.
What about is that the north side at the top of the image?
Yes.
Can a truck get around from Mansfield Ave to that side of the building?
Yeah, that's going to be a road on that. Yes, they have access to that as well.
Oh, is that the emergency exit?
That's correct.
Correct.
Emergency entrance.
And exit, need be.
Sorry, I didn't hear that.
And egress, I mean, you could have, there was discussions about it in like smaller trucks, an emergency ambulance picking up somebody off the shore and on the reservoir, and being able to loop around, being able to drive across and exit on the north side. There was discussions on that as well.
Okay.
So let me ask you, if I'm only looking, I forget, how far back, they wouldn't go past this point here? Is that what I'm hearing from you? They would never come behind the building?
Those are the comments we got.
Okay. Because I'm saying if you got and again, this is why we'd like to probably speak with the fire department. But if we were able to get a truck a little further back, that should grant them access to back here.
Yeah.
You would think, but again, I mean, that's just, I'm not a fire guy.
Right.
Well, let's ask and work on this to get the chief here. Okay, thanks. If we could continue now with Mr. Brennan's
Sure.
points here, though, let's try to get through these, at some level.
Sure. The next comment, number 5, was also about the emergency access on the north side of the building. So I think we can wait for the fire department to that one. 6 and 7 they've addressed. 8. The only reason why I brought up number 8 was if all of the garage spaces are occupied, there's no way for a vehicle to turn around that enters the garage. Their response was that it's going to be professionally managed and all the spaces will be assigned. So, I guess if the board's okay with that, that's.
A vehicle can't do a 3 or 5 or 7 point turn in the garage?
It would be tight. I mean, it's only a 24-foot wide aisle, so it's like your typical shopping center. If you went down a row in a shopping center and there's no way for you to turn around at the end and you're trying to turn around between the 2 rows of cars, it's rather difficult.
Oh, okay. There's no way to remedy that, though, under these plans, is there?
The only way would be to lose a space somewhere that you could turn around in.
Even a double space marked off with yellow paint. That they're right. Okay, well, something to think about.
Yep. My next comment was about the crosswalk, which Mr. Dirk had gone into already. And the reason why I brought that up was, mainly it was in the project eligibility letter from Mass Housing that they had suggested looking into a crosswalk too. So I was just kind of reiterating their comment there.
Okay, that's still open. Go ahead.
The next one, number 10, was addressed. Number 11 was the lighting, and they have since submitted a lighting plan. I think it came in either yesterday or this morning.
Has that been reviewed?
I looked at it quickly. I think my only comment on it was that they have in the middle, they show a couple of lights that appear to be basically right down the wall of the building, but they're shown inside and out and at 25-foot height. So I don't think that plan is really showing the lighting inside the garage at all. It's basically assuming that it's a wide open parking area from the looks of it. I didn't look at it in detail, but the way that plan looks, it's just a little strange.
Can you try to clarify for the next?
Yeah, I can. Yep, I will do that.
I don't mean to put it on you. I mean you and the.
No, that's fine. Number 12 is all set.
Could I ask a question on that? Could I back up? So you want a lighting plan for inside the garage? I thought the purpose was for the exterior.
No, it is for the exterior, but they're showing the lights. It's a double fixture. I can actually, I don't know if I can share a screen, but I actually have it here.
Yeah, I'll stop mine.
Okay.
There you go.
So if you see, everybody see that?
I do. I see it's illuminating and it's showing the illumination inside the garage.
Yeah. So this is a double.
Yeah.
Looks like a double-headed fixture, and that wouldn't be the way it is. It looks like they did this based on no garage being there. Looking around the perimeter, it looks like it's okay. You're not going to get, especially on the residential property on the north side, you're not going to get any noticeable light spillover. There's a little bit on the south side, but that's next to the commercial building up here. So
your comment is just that doesn't seem to make sense with what they're showing here. I get you.
Yeah,
we'll have that fixed for you.
Okay.
Sorry about that.
Yeah, no problem. I just
okay. Go ahead.
The next one, they submitted a landscaping plan. I haven't reviewed that in detail, but you know, it looks like a pretty robust landscaping plan that obviously the board should take a look at some point.
Is that, you're in line to do that, correct?
I can look at it. I'm not a landscape architect, but I can certainly take a look at, make some comments on it. But again, it looked like a fairly robust landscaping plan that they had.
Okay.
Um,
Number 13?
Yep, they didn't provide details, but they did specify that the chain link fence along the northern property line is supposed to have slats, and the dumpster shall have a solid fence enclosure. And that's just for screening. Both the chain link fences along the northern property line, that's the abutter on the north side. And then the dumpster enclosure, obviously you want that hidden from sight, and it's on the front side of the building. So I think they would want it hidden from sight as well.
Right.
The next 14 is some gravel specs, which I just think that they forgot to add those to the plan. Not a big deal.
Okay.
So they're going into utilities, water and sewer information, and they said they will work with Norton Water and Sewer Departments to ensure that they have adequate capacity.
Okay. Can I just ask, has the applicant made any progress on that? Have you contacted Water and Sewer or met with them, or no?
Not yet, no.
Okay. But that, you should probably, well, it's just my recommendation based on past interactions. You should probably do that sooner rather than later, because that came up in the last one, in the last 40B, a little bit late in the process, and I think it held us up a little bit. But
The current building itself has a 6-inch fire pipe servicing it, and we're looking into now being able to use that as the domestic and bringing in a new fire pipe as well. But yes, we'll be contacting the water and sewer next week to discuss.
Okay, go ahead.
Yep. So my next comment was about a drain pipe. There's an existing outfall pipe. Discharges onto the abutter's property to the north. In their response, they said that it appears to be Mass DOT pipe, which it does appear to be that. You know,
is that at the road? At the road then?
It does. It looks like it does take runoff from. Yeah, it takes
Is it
runoff
located
from
at the road area?
Yes, it's
Okay.
within the right of way. There's a manhole in the right of way, and the discharge pipe comes out of that manhole onto the abutter's property. And
Correct me if I'm wrong, but I thought the abutter spoke on that. I remember correctly.
maybe I wasn't.
Yeah.
This is the first one that I.
I think she might have raised runoff generally. I don't remember that specific, the drain pipe, but.
I think, if I may, there's an existing, Mass DOT drain pipe. It could have been installed by the town of Norton, I'm not sure, but it drains water from across the street and also drains a portion of Mansfield Avenue. What we're doing is we're going to allow that pipe to remain, to allow the street to drain. In the meantime, the catch basin that's in the gutter at the entrance, we're going to be closing that entrance. We're going to turn that into a drain manhole, maintain the connection to our property, but put in recharge chambers, as well as a water quality, proprietary water quality storm scepter to reduce the sediment. It might be a little bit of an improvement for the abutter, but it's going to be an improvement. I don't think there's much else we can do with the pipe on our property as well, on the applicant's property that crosses over and drains Mansfield Avenue.
Yeah, and I agree with Mr. Burke's assessment that they're gonna the runoff from the subject property will be less than it is existing, and it will be better quality because they are treating it. So I agree with that.
Okay, good.
I just question whether there is a legal easement, but
I don't think
That's
there is,
also,
but it's I think it's kind of moot. I think it's prescriptive based on the fact that it's there.
If you're not adding to it, I'm not sure why you would need to be concerned, right?
Correct.
I don't know legally if there's an easement or not, but it doesn't sound like there is. Okay, go ahead.
The next one was with relation to the stormwater bylaw. They were asking for a waiver from that, but they have, in their response, they said that they are going to comply with that, and Conservation's doing their own peer review for the stormwater. So I think it's probably best just to leave it to them at this point.
And where are you with the Conservation Department?
We just received the peer review letter. I went through it today. John Chessier wrote the letter, and there's a schedule to be made for he and I to sit down for a charrette, if you will, to hammer out all the minor details. If I could, the big item about this particular project is that you have, it's an 85,000 square foot lot, 70,000 square feet is impervious right now. And we're gonna, what we're proposing now is to increase the pervious area by 17,000 square feet. It's not often you can have that opportunity. And our test pits show sand, so it allows for recharge.
Excuse me.
So the compliance capability of this project is high for us to meet the stringent Town of Norton stormwater bylaw, and we'll be looking to do that. I think we can answer all of Mr. Chessier's and Mr. Brennan's concerns regarding the stormwater without too much trouble.
Okay. I'm just curious as to, the timing with conservation is, but it sounds like you're on that.
We are expecting to have that working session till late next week.
Okay, great. Could you continue?
Yes. So the next items 4 through 8 pretty much fall under that Conservation Commission.
Yeah.
Yeah. So I wouldn't even 9. 10 was the construction entrance, so they addressed that for the length of it. And they addressed the other 2 issues that I had. So I think it's mainly, the issues that we've gone over, and then, their dealings with conservation peer review at this point.
You're skipping to the end of your letter?
Yeah, because all of those items 4
I see.
through, they're all stormwater related.
Soils and things.
Conservation will be taking care of those. And a lot of them they've addressed, but.
Sorry, but 10, because I'm just looking at this for the first time right now. 25,
Yep, 10
stone apron.
Yep, they addressed that by making it 50 feet like I had asked.
Okay. And then
11 was the details of the erosion control, and they showed that they added that.
And the proposed gas line.
And they showed that now.
What's the gas line for the building itself?
Correct. Yeah, natural gas.
Is there one there now?
Yes.
There is. They show it. It wasn't labeled on the last set of plans, but they labeled it on the. It didn't really. I just didn't realize that it hadn't been labeled, and they took care of that.
So is the building going to be gas, heat, and cooking?
Yes.
I would expect.
Yes.
Heat and cooking and other, what else is there? Hot water. Okay. Okay, any questions further right now for Mr. Brennan on our behalf, or Mr. Burke from the board members? We have a few things to revisit next time, but I'm glad we went through all this to get everything out on the table, and we now have an idea of what else we need to look at more deeply. Any other general questions though? Then I guess, oh, I'm sorry, David, you're talking, but I see your mouth moving, but I don't hear you. Go ahead.
I just unmuted it. No, I was just gonna say, I don't have any questions, but I thought that was, Mr. Brennan did a nice presentation there.
Agreed. Thank you. And Mr. Burke, thank you for responding the way you have as well. Because it sounds like we're getting through the issues that we need to, be satisfied that we've looked at. Okay, so Ms. Sweet, what else do we have right now tonight that's new? Or Paul, if you realize that we're leaving something out of the mix. But Lynn, what else do we do?
I guess we had thought that Jim was going to run you around the changes that he made on the plan, but it sounds like some of them have come up naturally during the discussion. So I would leave it up to Jim as to whether or not there's anything else he wants to point out, because there were some, there were the changes around the fire, and then there was some clarifications.
Yeah, we said we would do it that way, and I kind of devolved, I guess, into another way. Mr. Burke, were there other significant change or non-significant changes that you wanted to highlight for us?
I'd say the biggest thing is the transition from asking for the waiver from the Norton stormwater bylaw and then actually changing the design to more work towards complying with it. A lot of proprietary stormwater quality units were installed. The layout of the building itself changed too. Some of the interior layout would change to make it a little bit more easier for usefulness for the residents, trap removal and that kind of thing. But for the most part, I thought Mr. Brennan's letter kind of ran through a lot of the changes that we made, and that's kind of the project that we're at right now. I think the big item is addressing the fire department and getting a hold of water and sewer, and I think we might be there.
Okay, so it sounds like we went over most of the things.
Yeah.
All right.
I did want to point out that we did give a pretty detailed waiver list. We did give a chart, just so that when in our initial submission, really all we're going to be changing on that waiver list from what I've heard so far is we're going to be removing the request for the waiver for the stormwater.
Okay.
And I can certainly resubmit that. I was waiting for this hearing to happen so that you don't get too many, iterations.
Well, no, that's fine. I appreciate that. I just heard from Mr. Brennan that the waivers are a little bit broad in some areas. I don't remember the waiver list. I think we looked at it briefly last summer, but if you want to sort of look at it, edit, and then give it to us again, I mean, I'll certainly go back and look what was there. But again, just be as specific as possible as to what, relief you're requiring. We're not stingy about it, but we don't like just blanket. And I think our 40B advisor consultant has, Judy Barrett, has said the same thing. You don't want to grant just blankets. You want specific items. So if you could do that, sure, we can look at that in some detail next time, whether it's the old version or a new version. It's 9:15 now. Is now a good time to break for the next meeting on March 24th? And I assume that would be a good date to resume. I'd ask, I think everyone's nodding.
Yes.
Probably nodding a yes to go home at this
point. I agree.
Turn off the cameras anyway. So we have a couple of things planned for the next meeting already. I'd suggest that we put this on for 7:20. Entertain a motion to continue unless there's anything else to deal with tonight. Let me just ask for the record first, actually. We'd like to ask if there are any members of the public or abutters or non-abutters, interested parties who have any questions or comments at this point in the process. We'd like to ask that question at each meeting along the way. I don't see or hear anybody tuning in to ask any questions or make any comments. So with that, if there's nothing else to discuss, is there is there and Paul, we want to contact the fire department and I think the police chief as well to ask about the accidents.
Right.
But we can, and ask them if they can to be present, have somebody present next time, especially the fire department. I think we need to ask a few questions.
Right, and I'll also speak to the conservation director about
Oh.
about them wanting to put more permeable surfaces there that might make a truck impassable. So I'll coordinate on that.
Okay, thanks. Thank you. And Patrick Brennan is going to look at a couple of things that he had just received or recently received, and he indicated he might want to take just a little deeper dive at. So, Mr. Brennan, you're okay with that and coming back on the 24th?
Yes.
Greatly appreciate your help. Okay, so then is there a motion to continue this to March 24th? It's not COVID, it's just a dry cough. At say 7:20.
Mr. Chairman, I'll make a motion to continue the public meeting to March 24th at 7:30?
Whatever is appropriate. Why did you do 7:20?
7:20, okay, sorry, at 7:20. The public meeting of 253 Mansfield Ave regarding the comprehensive permit.
Tenor will second.
Okay, just because if the other applications fall, we don't have to wait the extra 10 minutes to take it up. No further discussion. Thanks to everyone very much. It was a very productive meeting after a six-month hiatus. So thanks for bringing us up to date and answering a lot of questions. Mr. Tenori, how do you vote on the motion to continue?
Yes.
And Mr. Wren?
Yes.
Okay, and Mr. Noel votes yes as well. Thanks very much.
Thank you.
See you in a few.
Thank you for your time.
Thank you.
Thank you. Thank you.
Okay.
You too. Members, we have to stay on camera during the meeting. I'm just going to go get another can of soda. So I'm still listening. Who wants to sing, or Paul? What else do we have on the agenda?
Minutes and a bill. Do you want to take up the bill?
Sure.
It's actually for Pat Brennan and Amory. It's his peer review fee. And it's let me pull it up.
Do we have the bill? I did not see it.
It was a late edition. It's dated February 11th. It's for $1,480.
Is that it right there, Paul? No.
Nope. Actually, I'm sorry. It's for more. It's 4,120. Oh, did you? Okay, I'm actually not looking at Zoom. That's it.
So this is the bill submitted as dated February 11, 4,100. Whoop, it disappeared.
Just made it bigger for you.
I do that with my bills. I look at them and then they disappear. I just don't. And it's Mr. Brennan's firm and Gill & Associates as a subcontractor, the amount of $4,120.
Yeah.
What is it through a certain date? Just
Includes with our proposed date.
Wait, July 31st?
That's when that's
proposal.
when they had submitted their initial proposal.
Okay.
But
If you go back on the first page, it says January 1 to January 31st, I believe.
Yep,
Just at the top.
Yep.
Okay. And that includes a Gill and Bill. A Gill and Bill is subsumed in this. Thank you.
Right.
The
It's
faceless
for-
Nicole has made an appearance at our meeting.
I really am here.
So is there a motion to approve this bill to submit it for payment from, excuse me again, this is the peer review fund, right, Paul?
Yes.
To submit it for payment from the peer review fund. I think this gets approved by selectmen, then it gets submitted to the treasurer for payment.
No, you all approve it.
Okay, I thought it had to go through another, whatever the process is, that's fine.
Yeah, it's pretty simple, but we'll have you sign a form.
That I did get, you emailed to me today. It's just
Then we
sign
get it, then we get it directly to the treasurer and the town accountant.
Yep, okay. The consultants have been very helpful. I don't remember a first bill for them. Is this the first bill?
This is the first one, because remember, one of the things when this was all put on hold, they had not signed the contract to, they did not submit the fee for the peer review for us to deposit it. So this is the first peer review that that and John have done for this project.
Okay, and are there sufficient funds in the fund?
Yes.
Okay.
Yeah.
I don't remember what was deposited. I don't know if we even saw that, but that's the only contingency. So is there a motion to approve this bill for payment?
I'll make a motion to pay the bill in the amount of $4,120 to Amory Associates.
I will second that.
Okay. Mr. Wren, how do you vote on the motion?
I vote yes.
Mr. Tenori, how do you vote?
Yes.
Mr. Noel votes yes as well. I will sign the summary form and initial this, and I'll put, excuse me. I really am in good health. Just doesn't sound it. I will, I'll PDF them to you, but yes, I know I have to drop off the originals. I'll try to get the originals dropped off, tomorrow, probably not tonight, but tomorrow or Friday at the latest, Nicole.
That's fine. Thank you.
So we can get it paid quickly. I didn't do any work on the minutes. So I'm going to ask to put those off to the next meeting and hopefully get caught up again. Paul and I put in a lot of time on the 195 decision and the waiver list there. And as I reported earlier, council has it now and is looking at it. And so that's on its way and it should be good. I wanted council to take a look at it before I started distributing it, but I will show you the red line version over what, we had in front of us when we voted. I don't think we changed anything. We just, as I said, made edits that seemed to make sense in eliminating some double paragraphs and such. So I can get it, the red line out to you, but Amy might have more changes. Let's see in the next couple of days what happens with her if she gets it back to us. If not, maybe I'll just send out the red line to you anyway. In other words, showing the edits over what we were looking at on January 27 shouldn't be different except in form. Paul, you agree?
Yes.
I am comfortable with that.
Okay. Is there anything else aside from the minutes, which I shirked responsibility on? Anything else tonight, Paul?
That is it.
So we do have to drop a decision on the remand case, but council has offered her assistance with that. I'm going to press her on that, Nicole, tomorrow with an email. I don't know if she's going to do a draft or just provide us with some magic language, but we have to summarize, make it in good form.
Should I hold off on starting it or just maybe put some of the basic information together so I can at least...
You could sure put the basics together. It's an appeal.
Okay.
We just did an appeal last month, I think. So you have that form of the title and everything and the specific section. But yeah, sure. Put some of the basics together, starting with 2.5 years ago. The documents that are in the file, that sort of thing. Sure, that would be great.
Okay.
But that has to be done, within 14 days. So, again, council has advised, and the email chains in the file, you'll see that the appellate has also claimed we've already constructively approved, meaning approved his appeal over the building commissioner's revocation of his parking permit. But what we didn't get to tonight is there appears to be no relationship between Mr. Bankert, and the property anymore. The property is under contract. Right, Paul? It's part of a special permit application.
This is one of the sites, one of the marijuana retail sites that we have signed a host community agreement. As part of their package, we did see that the company, the retailer, has a signed lease with the property owner.
I meant to bring that up, and I totally forgot. Somebody remind me next time. I meant to bring that up during the traffic peer review, and I totally forgot.
You mean that an establishment, a marijuana establishment, is going to be in the area?
Yeah.
Yeah, that's within 500 feet of here on the other side.
That's going to be a huge traffic nightmare right there.
Is it?
They'll have to do a traffic study when that comes in.
Okay, let me ask a question. I haven't driven by. I kept saying I was going to go by the Attleboro store. Is that one still populated every day? Customers all the time? Is it? I mean, does anyone know?
I don't know the one at Attleboro. I know others that have. One down in Wareham is.
Oh, you know that? Okay. I mean, I just wondered if there were still that trafficked. You know.
I mean, they're getting. I guess I should say. In my opinion, no. You know, just my own opinion.
Yeah, that's what I'm at. I'm just
the more that come on, the less volume that goes to it, right? So.
It's not like last year.
What's that?
It's not like last year where there's only a couple in the whole state that are open. It's,
right, but still, I think, you know, nonetheless, it's still going to create some volume.
I remember one, I don't remember what town it's in, somewhere west of Boston, when it opened last spring, last summer. It was, you know, there were people directing traffic for a half mile out. You know, they did that. I don't know if that's going to be the effect in Norton. That's why I'm asking.
That was what we're finding is, you know, those few that opened, like that one was in Leicester.
Okay.
Those were the first two in the whole state. So you had the whole state coming to visit. But what I hear is now that there are so many out there, it's, you know, the supply is catching up to the demand. And so these stores are not as, you know, busy as, you know, obviously if you have 100 stores versus 1,000, you know, for a commodity that a lot of people want, then, you know, we don't know until it opens. I mean, but this will go through this special permit and site planning process, and we'll, you know, that's going to be a big issue. That's certainly going to be a big issue for both applications to address.
I wonder how the town is going to deal with its proximity to Xfinity Center. Aren't you going to have everybody who goes to Xfinity Center paying a visit on concert afternoons? You know, I mean, I don't know.
That may be more of a policing issue. But that's one of the reasons they wanted to locate there was you're off of course 5 Xfinity's there. It's very possible, but I think, you know, going back to the discussion we were having with 253 is it's a compatibility issue where if it's a commercial use, you know, you have an option to go there if you want to. When it's your house, you don't have an option.
Yeah.
But if it's a store, whether it's a, you know, a marijuana shop or a restaurant, you might go, I'm not going near there because there's a show tonight, or I don't go there because I know, you know, or, you know, I'm not going to go there between 3 and 7 because that road's just all backed up. So, you know, we have to factor all of that in when that, you know, when we're reviewing the special permit and site plan for that.
Also, Paul, a general question, aren't the stores required now during COVID, it may be just a COVID thing, to schedule appointments, or are they just doing that as a business practice? Because that's what I've heard happens.
I think that's more of a business practice.
Oh.
I could be mistaken. It might be related to COVID, but I know a lot of them are doing it. But I think a lot of them were doing it because of what happened at Leicester, and I can't remember the other town. That they want, you know, towns were concerned about having that happen. And so fairly quickly after, you know, the 3rd and 4th and 5th stores were opening, so they were coming up with these innovative ways of crowd control.
Well, I've seen some pre-ordering and then you go at an assigned time to pick it up, that sort of thing. I don't know. I don't know what's in store for Norton. I'm not
Well,
suggesting.
I could give you a little bit more information too, is the state allows delivery, home delivery. So, and actually we've been in touch with an applicant who is looking to have a home delivery license here. So
Okay. I didn't know that actually. Okay, well,
it's a new, yeah, it's a new day, I guess. But yeah, but it is a legal business, and we are, in fact, we're proposing some changes to the bylaw, again, to the marijuana bylaw to expand or clarify the home delivery option.
interesting. Can you get it on Amazon yet? You know, Amazon.com. What's your state? What state do you reside in?
It's called the Darknet.
Oh,
The dark net.
It's already there.
I don't know.
It was never not there, I guess, as you.
Yeah.
I don't know, but
okay.
you know, we'll see. You know, obviously this will be a heavily reviewed, thoroughly reviewed application. Both of them will be.
But talking about sidewalks in the area, not to talk about this development out of our public hearing, but you know, sidewalks in the area, if you're going to have that store there and this apartment building and 195 and Xfinity Center, the pedestrian crossing there, and again, I'm just talking very generally, pedestrians walking along there, it's lighted enough in that stretch for me, but I'll tell you, when you come around past the old Roach Brothers Plaza and get to the where Peter lives and you know, the reservoir area, invariably there's a person in dark clothing walking along that, sorry, I'm not, my eyes are not that old, you know, you don't see them until you're pretty close upon them. And
well, it's a very, that area is just not a pedestrian friendly in any way.
That's a much better way of putting it than what I just.
I mean, I'm all for adding the infrastructure, but we need to be, you know, we need a more comprehensive plan for people's mobility there, because putting a crosswalk in when there's no sidewalk on one side, boy, that's a risk. But we should have had sidewalks all up and down that street.
That's what I'm getting at.
Cross over the reservoir and you see people fishing there.
Yeah, right.
You feel like you're going to hit these fishermen.
Even when they're sitting on the fence and you're still like, whoa, what? I got to watch out.
Right. Right. So it's a big challenge. I mean, I know when Xfinity has a show where people used to park at 242 and walk it.
Okay. Well, we can't talk about it outside the public hearing, so.
Yeah. No, I'm not commenting on that. It's just the fact that that's close enough that people will walk to Xfinity from there.
Yep.
And they'll park at Roach Brothers.
Yeah.
And walk it. And
is there anybody enforcing parking at Roach Brothers now, since Roach Brothers isn't there? I mean, there's a big.
Well, if Roach Brothers didn't own it, it's Gator Management that would. You know, I don't know how they enforce it, but we know people park there.
Well, but we'll see. I mean, now that there's no anchor store there, it might really be open to people just using it as a parking lot.
Yep, that's right. That's right. Since Roach Brothers is closed, I see some people parked there. And plus, I walk there lots and lots of times from my place up to Alberto's for lunch. And pretty soon this summer, the Xfinity Center is going to be open up because it is an outdoor venue, and hopefully it will be open up in 2021 soon.
The chair recognizes Mr. Wiggins retroactively. Peter, thank you for your input.
Right.
March 24th, let's work on these things in the meantime, including the 195 decision, which, you know, we'll email you on in the next few days. Nothing else for tonight? Is there a motion to adjourn? Thank you for sticking around.
Thank you.
Motion.
Keep it consistent, Dave.
Well,
Motion to adjourn.
I'll second.
All right, no further discussion. Cutting off discussion. There will be no comment. Mr. Wren, I'm sorry, Mr. Wren, how do you vote?
I gotta say yes, right? Yes.
Mr. Tenori, how do you vote?
Yes.
Mr. Noel and Mr. Wiggins vote yes. Good night.
Good night, everyone. Good night.
Thanks, Nicole.